Richards?
Your Honor, Mr. Binger is either forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice.
First of all, Your Honor, this was the subject of a motion. I'm well aware of that, and the court left the door open.
For me, not for you.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. I did. I granted.
We did not move
that
to
was
reconsider.
their motion.
We have not filed any motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
So I'm attempting to impeach the defendant on his beliefs. I believe I'm entitled to impeach the defendant on his beliefs and on his statements.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call...
His statements too, Your Honor. Because he just said, can't use deadly force, can't threaten to use deadly force to protect property. So now I'm impeaching him on that.
Your Honor, the court has seen no reason to change its ruling. And just so this record is clear, in spite of the lengthy statement by Mr. Binger, before we started today, the court specifically stated in Mr. Binger's presence, there's been nothing to have me change any of my rulings. There have been numerous occasions during this trial where they've opened the door. The one time when they're going into Mr. Rosenbaum's the reason he doesn't like guns, and I said something, I whispered in Mr. Krause's ear, it's because of the prior convictions. Please stop. And he did. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense testimony.
Don't get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. If it's not similar, that's the whole rule. Those are all the exceptions to 90404. Check the authorities. Wigmore and evidence. Judge Weinstein. Colonel McCormick. It's The prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether premeditated murder or whether self-defense. That's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in, no matter what you think. Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line, close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
Pickle gang.